Hey, what's up everybody? This is Mike Riley, and in today's video, I'm gonna talk about some of the common evidentiary issues that come up at trial. In this video, you can expect to learn about pretrial motion practice, motions in limine, limiting instructions, some of the common courtroom objections, and how judges rule on these difficult issues about evidence. Let's get started. So when we're talking about evidentiary issues, we're talking about the code of evidence. Each state has a code of evidence, the federal government has a code of evidence, and these are the rules that govern what comes into evidence at trial and what is excluded. Lawyers spend a lot of time arguing about these issues. Certain facts you want to keep out of a trial, certain facts you want to get into a trial, and there's a lot of room for creative lawyering when it comes to evidentiary issues. So let's start by talking about pretrial motions. These are motions that lawyers file in advance before the trial and say, hey, this piece of evidence shouldn't come in, this piece of evidence should be kept out. Now, lawyers can file pretrial motions or motions in limine to keep evidence out for a variety of reasons. One of the most common reasons that lawyers file pretrial motions or motions in limine to keep evidence out at trial involves a balancing test found in section 403 of the Federal Code of Evidence. That section reads as follows: the court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusion of the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Now, like I said earlier, each state has its own code of evidence that can vary slightly from the federal rule, but today we're going to talk about the federal rule. So what does this balancing test mean? Well, on one hand, you have the probative value and you're balancing it against the danger of unfair prejudice, confusion of the issues, something like that. So what is probative value? Probative value is the tendency of a piece of evidence to prove a fact. And so that is balanced against the potential harm it could do. So let me give you an example. I once had a client who was a rapper. He had a lot of rap videos, and in some of those videos, he was rapping about guns, drugs, violence, all these other things. And he was on trial for murder. Now, the rap videos were posted way before the alleged murder took place, and they weren't speaking directly to the murder. But I was worried that the state was going to try and introduce this evidence to try and cast my client in a bad light. So I filed a motion under my state's equivalent of Federal Rule 403 and said any probative value contained in this evidence is outweighed by the danger of unfair prejudice to my client. So the probative value wasn't much. This video was recorded before the incident that he was charged with, and it wasn't speaking directly to it, but maybe it had some probative value. It shows him talking about violence, guns, things like that. But the danger that this would confuse the jury and really prejudice my client outweighed that little bit of probative value that it had, and a judge agreed and excluded that evidence from trial. It's a good practice to file these pretrial motions or motions in limine to make sure that things don't come into evidence, to address it beforehand rather than have something come up at trial and you object, but the jury's already heard it. And there's a saying in court that you can't unring a bell. So I think pretrial motions or motions in limine are a great way to address evidentiary issues that a lawyer anticipates are going to come up at trial before trial. It's a way of putting everybody on notice. Hey, tell your witnesses they're not allowed to talk about this particular issue. The other way that lawyers deal with evidentiary issues at trial is by objecting. We're all familiar with this. We see it on TV. The lawyer rises to his or her feet and says, objection. This evidence should be kept out for a variety of reasons. And a judge will rule on the objection on the spot. The judge will either say that the objection is overruled, meaning they don't agree with the objecting lawyer, basically sit back down, there's no problem here, or the objection is sustained, meaning the judge agrees with the objecting lawyer and says, yes, this evidence is inappropriate and that line of questioning should stop, and the other lawyer should drop that line of questioning and move on to something else. So you may be asking, well, what happens if a witness says something, the lawyer objects, the judge sustains the objection, but the jury has already heard that piece of evidence? So just to illustrate the example, I have kind of a ridiculous example. So let's say I have a client who's on trial for a robbery. And let's say this particular client once tweeted, "I like to punch children in the face," right? It has nothing to do with the trial. There's no probative value. But for the sake of this example, let's say that the prosecutors have a witness on the stand who's testifying, and this witness wants to take a cheap shot against my client and just throw it out there that, by the way, he tweeted that he likes to punch children. I stand on my feet. I object. There's several grounds to object to this. It's not relevant. Any probative values outweighed by the danger of unfair prejudice, and the judge agrees and sustains my objection. But the jury just heard that my client posted that he likes to punch children. So what do we do in this situation? What do we do when a witness says something, there's an objection, and it's sustained, but the jury's heard it? Well, I could move for a mistrial and say that the jury's been tainted. They were exposed to evidence that was inadmissible. It's gonna be in their minds, and my client can't have a fair trial now. But I think a judge is probably likely to deny that motion and instead propose that they give the jury what's called a limiting instruction. I do not like limiting instructions. An example of a limiting instruction would be at the end of the trial, the judge says to the jury, "By the way, you heard at one point that this client tweeted that he likes to punch children in the face. You are not to consider that evidence at all." I do not like limiting instructions. So we have bad evidence that was put in front of the jury, and then the remedy is to have the judge remind the jury of the bad evidence and tell them not to consider it. Let's just think about human nature. Is a jury really going to forget about that? Or is the judge just reminding them about bad facts that hurt my client? So in that situation, when a jury is exposed to otherwise objectionable, inadmissible evidence, I never ask for a limiting instruction. If that's the remedy that the judge proposes, I say thanks, but no thanks. We don't want it. So let's talk about some of the common objections we hear in court. There are a lot of them. I'm not going to cover all of them, but I'm going to cover some of the most common objections that I see at trial. The first objection that we commonly see at trial is leading. You'll see a lawyer stand up and say, "Objection, leading." So what is leading? What is a leading question? In order to understand this objection, we need to understand the distinction between a leading and a non-leading question. So on direct examination, that's when you are calling a witness, you are not allowed to lead. So on direct examination, a lawyer is permitted only to ask open-ended questions. So if there's a police officer on the stand, the lawyer that called that police officer would be permitted to ask that officer, "What is your present occupation?" The question does not suggest an answer. It is an open-ended, non-leading question. Now, cross-examination is different. This is when you're questioning the opposing party's witness. On cross-examination, you can ask all the leading questions that you want. And if you're a good lawyer, you're not going to ask anything but leading questions on cross. So again, that example, "What is your present occupation?" "I'm a police officer." That's a non-leading question. The leading version of that is if I have a police officer on the stand and I'm crossing that officer, I would just say, "You're a police officer." Some people will say, "You're a police officer, right? You're a police officer, correct?" But that gets a little old, in my opinion, saying right or correct after every question. If you're leading properly, you're only going to give that witness room to answer a yes or no. Never, ever, ever ask an open-ended question on cross. So getting back to the leading objection. So like I said, on direct examination, you can only ask non-leading open questions. So if on direct examination, a prosecutor calls a police officer and starts leading them, "You're a police officer, right? You responded to the scene on such and such a date. You were there when the crime committed." I could rise to my feet and say objection, leading, and that objection will likely be sustained because the prosecutor's not permitted to go there. Now, practically speaking, I'm not going to object to every single leading question because sometimes it doesn't matter. A great way to annoy jurors is to keep objecting over and over and over again. If the prosecutor's just setting the scene, I'm generally not going to object. However, if the prosecutor keeps doing it, I might want to check them, put them in their place, stand up and say leading, just to let them know I'm paying attention, and I'm not going to let them get away with violating the evidentiary rules. Another time I'll start objecting, even when it doesn't matter, is when the witness thinks they're clever and they're trying to take jabs at my client, they're trying to take cheap shots. I'm going to start objecting just to screw them up, screw up their flow. But generally speaking, you can object anytime someone is asking leading questions on direct examination. The next common courtroom objection we see is an objection for relevance. The relevance objection is codified in section 401 1 of the Federal Rules of Evidence and reads as follows: evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. So this is pretty easy to understand. It's either has to do with this case or it doesn't. So if somebody starts asking questions that have absolutely nothing to do with the case, if a particular question calls for evidence that has nothing to do with the case, has nothing to do with any issue that is in dispute at the trial, a lawyer can object on the grounds of relevance. A judge might ask the party seeking to get this evidence in, how is this relevant? And the other party would have an opportunity to explain why they think it's relevant, and a judge will make a determination: is this evidence relevant to this trial? Does it have any tendency to make any fact in dispute more or less probable than it would be without that evidence? The next common courtroom objection that we see is speculation. Objection, speculation. Now, there's really two versions of this objection. So if a witness is testifying and they're saying, oh, I was a witness to a bank robbery and I saw the guy come in with a mask and he was thinking to himself, well, I'm going to get as much money as I can. Objection, speculation. This witness does not know what was going on in the mind of the person who is robbing the bank. So you can object and say, this is not evidence that should go in front of the jury because this is this witness speculating about what may or may not have been going on. They have no direct knowledge of the fact that they're testifying to. Along the same lines, you could object to a question that calls for speculation. So again, if there's a bank robbery and after the fact, the defendant flees the scene and is unaccounted for several hours, and a prosecutor is a police officer on the stand. And if the prosecutor asks the police officer, what do you think the defendant was doing in the hours following the bank robbery? This is a question that calls for speculation. The prosecutor is asking the police officer to guess, what do you think he was doing? If the officer has no direct knowledge about what the defendant was doing at this time, this question calls for speculation and the objection should be sustained. Another common courtroom objection we see is asked and answered. This usually comes up during cross-examination. So if I put my client up on the stand, the prosecutor's cross-examining my client and keeps asking them the same question over and over again, maybe to hit a point home. If that question was asked and the witness already answered it, I could shut the prosecutor down, stand up, object, asked and answered. Pretty self-explanatory. This has already been dealt with. Move on. And the last common courtroom objection I want to talk about is an objection for hearsay. This is probably the trickiest objection to understand, but it is very, very important. Hearsay is defined as an out-of-court statement offered to prove the truth of the matter asserted, and it is prohibited from coming into evidence. However, the evidence code carves out several examples of things that are not hearsay and several exceptions to the hearsay rule, like excited utterance, dying declaration, admission of a party opponent. And at some point, I will get into the weeds on hearsay and make a video just about hearsay. It is one of my favorite issues at trial because there's a lot of room to creatively object and make creative arguments. If you're trying to get a piece of evidence in and the other side objects and says this is hearsay, the best way to deal with it is usually to argue, yes, it's an out-of-court statement, but I am not offering it to prove the truth of the matter asserted. Now, this is where it gets a little complicated, but I think you're going to be able to understand this if I give you a couple examples. So first, let's talk about an out-of-court statement that is offered to prove the truth of the matter asserted. And this would be hearsay, and this would be inadmissible. So let's say there's a victim of a crime who got beat up. That person is at the library and they see a friend of theirs, and their friend says, "What happened to you? You're all marked up, you're bruised up." And the victim says, "Well, John Doe beat me up last weekend." Now, the person that heard the victim say that cannot come to trial and offer evidence that the victim told them that John Doe beat them up, because the victim's statement that John Doe beat me up is being offered for the truth of the matter asserted. If somebody's trying to introduce that evidence at trial, they're trying to introduce that evidence to show that John Doe beat up the victim. Now, the victim could come in and say John Doe beat me up because they're not talking about an out-of-court statement. They're talking about their own observations and experience. So in that situation, an objection for hearsay would be sustained. Now let's talk about an example where we're trying to introduce an out-of-court statement, but we're not trying to offer it to prove the truth of the matter asserted. So in that same example, let's say the victim is at the library, their friend comes up and says, "What happened to you?" And they say, "Well, John Doe beat me up last weekend, and also I was abducted by aliens shortly after." Now, like I said earlier, the witness, the friend, can't come into court and say that the victim told me that John Doe beat them up. But on cross-examination, I could ask that witness, say, "Didn't the victim tell you that they were abducted by aliens last weekend?" I am not offering this evidence to prove that the victim was abducted by aliens. I'm offering it to prove something other than the truth of the matter asserted. Quite frankly, I'm offering it to show that the victim is a little loony, maybe is making things up, a little bit delusional, so I can argue to a jury that this person lacks credibility and you shouldn't believe their testimony. Again, it gets a little complicated with hearsay, and we'll do a video at some other point about that. So what do you think? Do you think it's a better practice for lawyers to file motions in limine on every single evidentiary issue they anticipate coming up at trial? Do you think it's a good idea to ask a judge for a limiting instruction? Do you understand the distinction between a hearsay statement and an out-of-court statement that is offered for some other reason than to prove the truth of the matter asserted? I'd love to hear your thoughts and comments. Thank you for all the support, and thank you so much for watching.